Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-XRP attorney John Deaton commented on the rumors, saying Clive Thompson, a well-known investment manager, expressed an extraordinarily enthusiastic perspective of Ripple and its native cryptocurrency, XRP, in a recent live-streamed conversation with Black Swan Capitalist founders Versen and Vendel Al-Jara. The revelations come at a critical juncture since Ripple just won a partial legal win against the U.S. Securities and Exchange Commission, SEC. For those who are unfamiliar, the SEC is the regulatory entity in charge of securities in the United States. The continuing legal dispute with Ripple is about whether XRP should be categorized as a security. In July, Judge Annalisa Torres ruled that XRP did not meet the threshold for classification as such, giving Ripple a partial victory. Nonetheless, the matter remains unsettled since the SEC responded with an interlocutory appeal. Thompson sees the complexities of this legal issue as a two-edged sword. On the one hand, the ambiguity surrounding regulatory frameworks poses issues for the Bitcoin industry as a whole. On the other hand, he believes that this uncertainty unwittingly creates a canvas for innovative technologies like as Ripple to demonstrate their potential. Thompson extends this line of thinking by drawing comparisons between Ripple's prospective development trajectory and the phenomenal success of technological behemoths like Amazon, Google, and Apple. He believes Ripple will become so entrenched and vital that any efforts by the SEC to limit its activities would be useless. The wealth manager's bullish viewpoint is consistent with Versen's statements during the interview, in which he said that the most likely regulatory conclusion would be a balance between Thompson gives credibility to Judge Torres's order and expresses optimism that Ripple would defeat the SEC's continuing appeal. His vision depicts Ripple as more than just a player in the financial technology space, but as a cornerstone capable of standing shoulder to shoulder with some of the world's most influential businesses. The legal battle between the U.S. Securities and Exchange Commission, SEC, and Ripple Labs continues to develop new plot points. It's important to remember that the SEC sued Ripple for the unauthorized distribution of XRP in the form of security. In addition, Judge Torres determined that XRP does not meet the definition of a security. The SEC has started a move to file an interlocutory appeal addressing programmatic and other sales of XRP as the trial approaches to determine whether Ripple CEO Brad Garlinghouse and Executive Chairman Chris Larsen assisted Ripple in selling XRP to institutional investors. It was in that document that the SEC shifted its tone, calling XRP nothing but computer code with no inherent value and stating that it had no interest in reviewing the underlying asset. Regulators in the United Kingdom have joined others who say cryptocurrencies have no true worth. However, as noted by cryptocurrency expert and attorney Bill Morgan, the SEC is now arguing before courts to have them rule that cryptocurrencies are not commodities. He notes that the SEC would be very dissatisfied if Judge Torres were to classify the Gram token as a commodity. Morgan says the SEC is trying to streamline its operations by having the courts rule that cryptocurrencies fail the Howey test for lack of intrinsic value. This implies that issuers of cryptocurrencies will have to find some practical use for them. Therefore, the third Howey pillar is met, and investors may place their trust in the results. The value and price growth of cryptocurrencies would be null and void without them. Since XRP's worth is contingent on its attributes and the XRP ledger XRP, Morgan argues that this method is incorrect. The Australian attorney contrasts the view that this is a new rail for the international payment system with one that compares it to wheels. Their worth comes from being put together, much as wheels did, and that's why they were able to revolutionize the globe. The SEC's apparent effort to treat Bitcoin and other cryptocurrencies differently raises the issue of why. The SEC has totally lost sight of its goal and purpose, according to another senior attorney in the industry, John E. Deaton. Although the SEC's position that XRP is a security has been supported by a memo from 2018, Deaton believes that this letter does not confirm the SEC's position since it is not public. Years of ambiguity ensued as Ripple sought clarification from the SEC, only to be instructed to keep talking to his staff about that, and ultimately given the runaround. After the document was released, Bill Hyman famously argued that Ethereum and Bitcoin were not securities. CEO Brad Garlinghouse at the time said, "Ripple is living in purgatory," Many believe that the lawsuit and the SEC's continuing enforcement activities against Ripple and XRP are to blame for the cryptocurrency's lackluster price performance. Prior to the litigation, XRP was the second most valuable cryptocurrency and was widely regarded as the currency of the future for the financial sector. Ripple Labs has stated its dissatisfaction with the SEC's request for an interlocutory appeal in court, joined by its senior executives, Brad Garlinghouse and Chris Larson. Ripple claims that the present court verdict does not support an appeal and points to the SEC's selective regulation of the cryptocurrency sector. This selective approach raises questions about how the SEC implements the Howey test, which determines whether a digital asset is a security or not. This discovery has far-reaching implications for the current court dispute. The SEC identifies no prejudice that it would suffer in being required to try the allegations that it brought and has maintained against Mr. Garlinghouse and Mr. Larson for nearly 3 years, according to a portion of the petition released by attorney James A. Key. Fallon. And the SEC refuses to recognize much alone remedy, the significant damage that additional delay will inflict the individual defendants. The SEC's half-hearted stay motion lacks legal, factual, and equitable basis. According to attorney Fred Rispoli, Judge Torres is unlikely to grant the SEC's motion. He claims that not only does the legal analysis back Ripple, but there is also serious worry about possible injury to people such as Brad Garlinghouse and Chris Larson, rather than merely the firm. He compares this to the entitlement to a prompt trial in criminal matters. He goes on to say that the only way Judge Torres might certify the appeal is if she sees the matter as very political and wants not to get too engaged. In such a case, she may choose to refer it to the Second Circuit, enabling them to determine whether or not to grant the appeal, thereby putting the decision in their hands. According to Rispoli, Judge Torres does not support this technique. The SEC is requesting an interlocutory appeal, claiming that the Ripple case poses fundamental legal issues with far-reaching repercussions for the entire digital asset market. Ripple has countered with many arguments. In the midst of the legal saga between Ripple and the SEC, John Deaton, a legal champion for XRP investors, provides a ray of light. He reveals the legal complexities that might lead to a settlement between Ripple and the SEC. Deaton's insight comes at a critical juncture, the legal battle between Coinbase and the SEC. If the court rejects Coinbase's request, the regulatory environment for token sales, including XRP, might change substantially. A rejection like this would erode the SEC's power to appeal, pushing the agency toward a settlement with Ripple. Deaton believes that even if an appeal were viable, the agency's power would wane, making a settlement more appealing. Ripple has also not been idle. In a recent filing, it argued that the SEC had strayed from legal principles, particularly with regard to the Howey test for token sales. This development follows a positive July verdict for Ripple, which prompted numerous exchanges to consider relisting XRP. A settlement between Ripple and the SEC might not only pave the way for XRP, but it could also have an impact on the larger cryptocurrency industry, setting new precedents. If the move to dismiss is granted, the future for Ripple and Coinbase appears more bright. Such a decision would establish new precedents in the crypto industry, providing much-needed clarity and encouraging innovation.